Yeah, sir. Good evening, sir. Good evening, sir.
Sir, good evening.
Yes, yes, yes. Good evening, sir. Thank you, sir.
Yes.
ನಮಸ್ಕಾರ.
Namaste, sir.
Namaskar. So, how many are there in the room? 51 of them.
Yes, sir.
Yes, sir. Good evening, sir. This is Kalpesh Gupta, sir. From
Hi, Gupta ji. How are you?
fine, fine. Thank you for joining, sir.
Good. Pleasure.
Thank you, sir.
Okay. So, how many registrations you read?
Sir, 500, 680, sir.
Oh my God. Okay.
Yes, sir.
And in WhatsApp group, 950 are there in WhatsApp group.
Aha.
So they may be filling up maybe today or tomorrow.
Good. By the way, is it already on streaming? No, no.
Yes, sir. Yes, sir. We are streaming it in on YouTube also, sir. YouTube channel of our institution, sir.
You are yet to start the streaming?
Yet we have not started, sir.
Yeah.
We are about to start. Yes.
Yeah. Formally, once we start, I want to start moderating.
Yes, sir. Yes.
एक दोनला उठायचा
Good evening, participant. Yes, so good evening, participant. Thank you very much for joining. We'll be starting in a couple of minutes. Good evening, Mallikarjun sir. Shall we start?
Yes, Kalpesh, we can go ahead.
Yeah.
Sir,
Am I audible to you, Kalpesh?
yes, sir.
Perfect, perfect. Will go.
Yes, sir. Yes. Kalpesh, sir, shall we begin with, sir? Yes, sir. First, there will be.
Karan, you are on mute.
Yes, sir. Sir, shall we begin, sir?
Yeah, we can start.
Yes, yes, sir.
Good evening, ladies and gentlemen. I, Sarfraz T. Singh, the Assistant Professor of K.L.E.Society's Law College, Chikkodi, welcome you all to the inaugural session of 7 days capacity building program, faculty development program, jointly organized by K.L.E.Society's Law College in association with Pro Bono India. Without further delay, I would like to request Dr. D.B. Solapure, Principal of K.L.E.Society's Law College, Chikkodi, to welcome the chief guest of today's inaugural session. Over to you, sir.
Thank you, Professor Kazim. Good evening, everyone. Honorable Chief Guest, respected dignitaries, esteemed resource persons, distinguished faculty members, and dear participants. It is my proud privilege to extend a warm and heartfelt welcome to you all on behalf of the organizing committee to this 7-day faculty development program, capacity building program on access to justice. Today marks the beginning of an important academic and professional journey, and we are truly honored to have your gracious presence for this inaugural session. At the very outset, on behalf of organizing committee, I wish to express our deepest gratitude to Dr. J.M. Mallikarjunia, Honorable Chief Guest, for accepting our invitation and joining us today. Sir is a distinguished academician and legal scholar currently serving as principal at K.L.E. Technological University Law College, Bengaluru. Sir is widely respected for his commitment to legal education, academic leadership, and promotion of access to justice through teaching and training. His career reflects a blend of scholarship, pedagogy, and institutional leadership, making him a key figure in the field of law and justice in Karnataka and beyond. Sir, your presence adds immense value to this program and inspires us to pursue the noble mission of ensuring justice for all. We look forward to your words of wisdom and guidance, which will undoubtedly enrich our deliberations. We welcome you, sir.
Thank you.
On behalf of organizing committee, I deem it great privilege to extend warm welcome to Dr. M.R.K. Prasad, Professor of Law, V.M. Salgaonkar Law College, Goa, for accepting our invitation to be a resource person for first session of this program. Welcome, sir. I extend my heartfelt welcome to Dr. Kalpesh Kumar Gupta ji, founder, Pro Bono India, for taking initiatives and guiding us diligently to organize this meaningful program. Welcome, sir. I also take this opportunity to extend warm welcome to all my colleagues who always shows their dedication and cooperation in all our endeavors. Welcome you all. On behalf of the organizing committee, I extend a warm welcome to all the participants, stakeholders, and students joining us from different institutions and locations from this online faculty development program. Welcome you all. The theme of this program, Access to Justice, is both timely and significant. Justice is the foundation of democracy and ensuring that it is accessible to every citizen, regardless of social or economic background, is a challenge that requires collective effort. Over the next 7 days, participants will engage in lectures, workshops, and discussions led by eminent scholars and practitioners. As we embark on this journey together, let us remind ourselves that justice is not merely a constitutional promise, but a moral responsibility. May the deliberation of this program pave the way for new ideas, stronger commitments, and impactful outcomes. With these words, once again, I take this opportunity to extend my heartfelt welcome to all our distinguished guests, participants. May this program be a beacon of knowledge, inspiration, and transformation. Thank you, one and all.
Thank you, sir. Now I request the chief guest, Dr. J.M. Mallikarjunaya, sir, to inaugurate and deliver the keynote speech. Please, sir.
Okay, good evening all. My dear friend and the principal of K.L.E.Society College, Mr. Karan, and the esteemed Professor Dr. Kalpesh Kumar Gupta, the founder of Pro Bono India, my dear colleagues at K.L.E.Society College, student friends, and most importantly, the esteemed fraternity in law. It's a overwhelming experience to have the presence of so many on this room. That only shows how much the legal academia is concerned about participation in such activities and trying to take the responsibility that is on our shoulder to the next level. Let me congratulate to start with the pro bono work, in fact, which has been taken forward by the organization Pro Bono India and also K.L.E.Society College, Chikodi. Hearty congratulations to you. It is really appreciable thing that you have come up with, and I wish you a very grand success in accomplishment of the task that you have kept before you. Well, the whole program for a week's time is planned to enable teachers. It's appropriately called the capacity building. What are the capacities that we build try to build from our side? What are the capacities that the participants in good number would try to secure over a week's time is what I would like to be rather trying to address and throw some light on this aspect. Well, while the theme being access to justice, which is going to be trained with the faculty of law, I was wondering, as the days have changed, but the work of teachers has remained the same in the sense the role that is given to this profession, what we call as nobility of the profession, nevertheless remains noble, but a lot of things have changed that has created some disturbance. Like we say, children are able but do not have focus. Technology has made the teachers redundant. Children wants to learn or know from Google, not from the teacher. Thus, the classroom activity has become a challenge, is one of the things which, as teachers, we face. What needs to be done about it? A lot of writings, lot of lectures, lot of advisors come in this direction. The first thing that comes in this direction is that a teacher must know better than students. Students have access to information today. First of all, a teacher should acquire more and more knowledge, is what has been conventionally told. And that is true, there is no doubt about it. A teacher should know more and more, absolutely no doubt about it. He should be the repository of knowledge, there is no doubt about it. But as the things changed, the access to information has become so easy, so ready, and the information is available to you in crisp form. I must also give weightage to or credit to the young generation who know the language, who will understand things quickly, who will analyze them as well. Thus, that makes the conventional teacher in a sense redundant, and teacher has to keep pace with the changes that are happening in the field. What are the changes that are happening? It's not enough today for a teacher to know things, but to analyze the knowledge that is available at the fingertip and to tell the students as to how to apply this knowledge to the fact situation. That is where, dear friends, the new idea, that is, it's no more the teaching, teacher is no more the teacher, it's all the more the learning, and the teacher is the facilitator in a classroom to ensure the learning. Thus, very aptly, today, the education has become not a teaching but a learning. The learner is kept at the center. The teacher assumes the role of facilitator. We have got to accept this idea for the reason, as I told you already, a very well articulated lecture of mine for 1 hour may be well understood, and the students may come up with 5 crisp points from 1 hour of lecture. Though I might have well articulated my lecture and given some points, my lecture must have led to concluding of some 5 points. These 5 points at the click of the at one click are available. That's enough for the students to analyze. That's where I become redundant as knowledge giver. So we must elevate our status from that of knowledge giver to that of the one who helps children to apply that law. In other words, the skill development. This is where we will notice that age-old dilemma which the law schools face. And the dilemma is this: are the law schools, or is a law school or lawyer's school? Generally, in law school, only theories are taught. Lawyerings are not imparted. Such law school remains the law school. Should we also teach lawyering skills? There is no doubt about it, since our graduates are going to be advocates, taking up some jobs. It is necessary that a law school must impart some skills, thereby try to elevate itself to that of lawyer school. It's not necessary that we must abandon one and become the other. The blend of law school and lawyer school should be our approach as educators in legal education, is what I believe. Well, having said we must stop becoming or assuming the role of repository of knowledge and keep transferring the knowledge to the students, which is not going to be appreciated or helpful. We must assume the role of ensuring the learner. When we say I assume the role of ensuring the learner, what is that we will ensure in learning? There are 3 important aspects which the new pedagogic method called the outcome-based education, which has been part of new educational system in all private universities and other universities as well. The outcome-based education emphasizes rightly on 3 important things. I wish all of you to know this. The 3 important things that are emphasized in OBE, outcome-based education, are these. My graduate should have knowledge. My graduate should have the skills that are necessary to use the knowledge he has acquired, that is to say, application. Last but not the least, attitudes. My graduate should have the right attitudes. So the true education today must concentrate on giving of knowledge, development of skills, and developing right attitudes in the students so that a future of the nation lies with them. In fact, enough has been done in giving knowledge. Some attempt has been done continuously with varying degree of success about imparting skills. But unfortunately, the development of right attitudes in the students, developing values, subscribing to values, value driven actions has been a casualty. This is one that we as law teachers must concentrate. Take it from me, when you give the knowledge and skills adequately, you may not become an inspiring teacher, you may remain a good teacher. When you try to imbibe the values in the student, what values am I talking about? As lawyers, we are appropriately called the social engineers. Apart from earning livelihood, apart from maybe making wealth, it's possible always to have some concern for the society, have some concern for the client, have some concern for the downtrodden, whatnot. It's possible in every action of ours. If there is some value driven attitude that will serve the purpose of uh, attitudinal developments, right attitudinal developments in the students. So, this is one thing that all of us have to be keeping in mind. It's not only the OB and new education policy. Today, the as an offshoot of new education policy 2020, the NCRF, namely National Credit Framework, and UGC guidelines. Lot of such regulatory guidelines or framework speaks about implementation of outcome-based education. Outcome-based education would be complete. To wrap up this idea, outcome-based education would be complete if we are very conscientiously trying to give knowledge, impart skills, and to develop right attitudes in our graduates. Let this be our mantra as administrators in education, as teachers. Well, having said OBE as the formula to keep the learner at the center of the activity and to ensure the accomplishment of educational goals today. Let me come to the next aspect. How the teaching becomes noble, what attractions that are there in teaching, though it is a cliche to say teaching is noble, it gives passion, etc. Though it is a cliche, all of us, every time we experience a good lecture being delivered, and the eyes that were on you, the students who attended your lecture, gestures on their face, the responses their eyes give, stand testimony for the good work you have done. When you understand that there is appreciation from the gestures, from the eyes that speak for your feedback, how satisfied one would be. Thus, it's impossible for anyone to become, should I say, successful, or anyone to become good teacher. It's impossible unless you share that passion. Of course, none of us have taken up this, should I say, occupation, work, or profession. Better we'll call it the profession. None of us have taken it up for the sake of passion. We all have taken it up for the sake of livelihood. But Should the livelihood and passion be different? Not necessary. Having chosen teaching for livelihood, it's always possible to see and foster the passion part of teaching. Thus, let's get committed to this passion part. Well, if you agree that there shall be passion, one must be passionate, and new pedagogic methods have to be developed on the basis of new educational goal, namely OBE. There is often this question asked, that is, which is the right method of teaching? There are a lot of teaching methods, right? Of those teaching methods, which is the right method? If you ask that question, the subject is so fluid, subject is so creative. And if I may give this analogy, when we talk of interpretation of statutes, when we talk of a subject called interpretation of statutes, if you ask me what is the right rule of interpretation of statutes, there is no such right rule. The rule that you apply, the rule of interpretation of statutes that you apply. Hello? 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 Am I audible?
Yes, sir. You're audible,
Yes, sir,
sir.
you're audible. Audible.
Perfect. Sorry, there was some error from my side. Well, I was telling you, I was trying to give the exam analogy of interpretation of statutes, and I was saying there cannot be something called right rule. Right rule depends on the situation, isn't it? On the same lines, Glanville Williams quotes this in his book on learning law. He writes about golden rule of interpretation of statutes. You will be surprised to hear this observation of him. He says, golden rule of interpretation of statutes means there is no golden rule. There cannot be something called golden rule. What is the golden rule would depend on facts and circumstances of the case. Coming back to what I was telling you, the question that I had raised was, which is the right method of teaching? There cannot be something called right method of teaching. They say, and they say it well, that method of teaching is the right method where the learner learns. Remember, this is so interesting. We must remember it as teachers, whether it is lecture method, discussion method, whether it is clinical method. As teacher, it would be great if one remembers that teaching method where the learner learns is the right one. Rest are all wrong ones. What is that right method where my learner learns has to be figured out by each of us in each of our classes. All right. Well, then when I spoke of this OBE, these days teaching has been a bit stricter task. Educators in teaching wants you write and blow up the syllabus. First, I want you to write the course plan. Then I want you to tell me, as a teacher, you must tell me which topic is going to be delivered through which pedagogic method. What are the learning resources I share? What are the assessment methods I will implement for you? How am I going to grade? I will come up with rubrics. So systematic the teaching has become now. This, should I say, unfortunately. This unfortunately raises a question in the minds of some teachers as to, is teaching an art or science? Everyone likes to call teaching an art. But tell me, this is my challenge always, which art comes without science? When I say science, systematic way of predefined thing. Which art comes without science? You go to learn dance, you go to learn music, you go to learn painting and any other art. Every art has a method to learn that art and method to master that art. Only going through this method makes you the master in that art. That being the case, why teaching shall not have a science in performing it? That's why through this observation, I would like to strongly suggest to all of you that our activity of ensuring the learning must be scientific one. That's why, of course, there is an art part in this. That's why we ended up observing this as it's a scientific art. You will be surprised to hear this expression. Others may be surprised, but as lawyers, we will understand what the lawyers different type of expression. So in order to be successful in our teaching, it would be great if we develop as teachers this attitude of having the scientific art as the way to accomplish our purpose of ensuring the attainment of goals that we would have defined. And those goals are called in outcome based education the outcomes. So, last but not the least idea I would like to share and close my talk is this, that having adopted outcome based education, it is not for educators to bring the top aspect in the world or highest knowledge or greatest knowledge. It is the doable thing that is called. You will be first talking about the outcomes. What outcomes I am capable of ensuring the attainment? What outcomes my students are capable of achieving? What resources that exist for me to attain those outcomes? What is the timeline that is available for me to attain those outcomes? The things like that, the factors like that have to be kept in mind, and then the outcomes are defined. After defining the outcomes, those three things I was telling you, giving of knowledge, imparting of skill, and attitudinal developments. Keeping these approaches in mind, we must try to attain these outcomes. Of course, I believe I have not spoken anything in particular, but tried to give you broad approaches that we should have as educators as you go ahead with your learning through the esteemed and scholarly professors for a week's time. Keep these approaches that I have shared in your mind and try to appreciate and learn from the lectures that come henceforth. And with these observations, once again, I thank the organizers, thank all the people in the room, and wish you all a very happy learning experience. Thank you. Thank you, one and all.
Thank you very much, sir.
Thank you, sir, for your valuable and thought-provoking words. Now, I request Dr. Kalpesh Kumar Gupta to propose vote of thanks.
Yes, thank you very much. Prasad sir, are you there? Prasad sir has
Yes,
joined.
yes.
Yes, welcome, sir. Thank you, sir. So yeah, I got to know, sir, Prasad sir and Malika Arjun sir have a good friend. So Dundappa sir told me, yes, yes, sir. Thank
Thank
you
you,
very much, sir.
sir.
Yeah, I just
Thank you very
missed
much, sir.
half of your speech.
Thank you very much, sir.
Okay.
Respected Malika Arjun sir, respected Prasad sir, Dundappa sir, and Mr. Kazi, and all the faculty members joined from all over the India. So first of all, I'd like to thank Law College Chikodi, the KLE Society, for giving this opportunity for us to organize this particular the program. When I got the proposal access to justice, so I thought of, because already we have done 5 additional course on legal and allied laws. Prasad sir is also part of this particular course. We have done five times, and various other course related to access to justice. So I was thinking what to put in a week program. So I thought of let me start with introduction to access justice. So I readily asked immediately, sir, readily agreed, Kalpesh, I am there for all the time. So sir agreed, Prasad sir, and then focus on access justice for women, children, differently able people, senior citizens, transgenders. That's why we planned on this particular week. Little bit differentiation from others program what we have done last 4 5 years. And then I'm happy to inform you, like we have received around around close to 1,000 people are there in WhatsApp group, and the 700 plus they have registered from all over the India. And for last couple of years, we started putting capacity building program in FDP. What used to happen earlier, because FDP again we will restricting to faculty only. So that way we what we are putting CBP and FDP. So each and every person, like from first year, I have seen some first year, second year student, they are very much enthusiastic about learning this particular topic, including this today's topic, access justice, legal aid, or any other topic that we have done earlier. So I hope participant will get. And then Mallikarjun sir, you rightly stated, like we should not become a good teacher only. We have to inspire. So whenever get the opportunity, and then I also learning from all of you, from all of you from stalwarts from all over India, including Prasad sir and other participants are there from they are also attending this particular program. They're seniors, like having 25 30 years of experience. They have been attending, so it's a great I would say moment of pride for us. They are also attending. It's not like senior like junior people, juniors to faculty members or students, they are attending, but we are seniors who are HOD, principal, deans, also they are attending this particular program. And then whenever I request all the participant faculty members, when you get the opportunity, and at least stated Mallikarjun says, try to inspire whatever subject you are teaching. And I keep telling, very first class, I tell I don't complete syllabus. This is my line in my very first class. So I keep talking about a lot of things, and then we have to inspire students rather than feeding them. Right now, we cannot teach each and everything. Right? I think I would say 3.5 months subject particular semester. So it's not possible. So I hope participants will get a lot of insight on this particular topic. And this is the buzzword, I would say, access to justice last 4 5 years. I think Prasad sir will agree. This access to justice, that word has become very popular, and a lot of things are happening in this particular direction. So on behalf of the organizing committee, we are grateful for Mallikarjun sir, Prasad sir for joining, and then participant for joining from registering for this particular program from all over India. All the very best, sir. Thank you very much. Over to you, Mr. Kazi.
Yes, thank you very much, sir. Now we'll begin. Yes. Now we will begin the session, and to take it further, I would like to request Professor Ganga uh, to to take over.
Just give me a minute to share. Uh, Good evening, everyone, and I hope you are able to see my PPT and able to hear me.
So there is an introduction, sir. One second, sir. One second, sir.
Okay.
Good evening, everyone. With great honor and immense pleasure, I, K.L.E.Society, Assistant Professor, K.L.E.Society Law College, Chikodi, take this opportunity to welcome our distinguished resource persons, Professor M.R.K. Prasad and founder of Pro Bono India, Dr. Kalpesh Kumar L. Gupta, and Dr. D.B. Solapure, Principal, K.L.E.Society Law College, Chikodi, all faculty members and participants joining us from across the country. The strength of the law lies in its accessibility to every citizen. Access to justice is fundamental to the functioning of a democratic society. It ensures that laws are not just written on paper, but are practically enforceable for every individual. To help us in understanding the access to justice, we have with us today Professor M.R.K. Prasad. Professor M.R.K. Prasad, Professor of Law, is one of India's foremost experts in clinical legal education and a pioneering voice in strengthening access to justice. He has been associated with V.M. Salgaonkar Law College since 1996, where he later served as Principal and Dean, Faculty of Law, Goa University. Dr. Prasad has played a transformative role in establishing community legal aid clinics, an initiative that earned his institution the Institutional Excellence Award 2011 from Society of Indian Law Firms and Menon Institute of Legal Advocacy Training. His contributions to national committees, including those constituted by the Chief Justice of India under NALSA, have shaped guidelines for legal aid clinics across the country. An esteemed academician, international collaborator, and prolific author, Dr. Prasad continues to champion legal literacy, community engagement, and practical legal training, two pillars of ensuring access to justice for all. I welcome you, sir. Without further delay, I warmly invite Professor M.R.K. Prasad to take over the session and enlighten us on introduction to access to justice. Over to you, sir.
Thank you. Thank you, Ganga. And let me thank first Mallikarjun sir, the principal of K.L.E. Law College. He is here. And also Kalpesh, a partner in crime for so many activities. Thank you, Kalpesh, and it is wonderful to see that there are so many participants registering for the course. That shows your genuine efforts from the knowledge teach and also the KLE Law College. When Kalpesh asked me to talk about access to justice, I was taken aback a little because I hope we have students, teachers here in this group. There are lawyers and judges who are not part of this, but all of us are involved some way in access to justice. We have our different roles in promoting access to justice. Therefore, the first challenge for me is how do I address this introduction to all? That's a challenge. When I looked at the topic, it basically consisting of two words. One is access and other is justice. Alpesh, are they allowed to speak or they can type?
They can speak, sir. They can speak. Can invite, yes, sir.
Okay. Maybe because I'm a clinical teacher, generally I don't like online courses because it's difficult to have those clinical way of teaching. But limited accessibility, we will try to do that. So, can anyone say what do you mean by justice? Or you can just type it there. I can see. Please do not worry.
Equitable behavior
Okay, very good.
among
Okay.
the person and according to the according to the law.
Very good. And please don't worry about your statements because nobody able to define on anything in law. We always have problems with the definition. According to you, what you understand. Okay, somebody said yeah. Because we are talking about access to justice. So let us, yeah, fairness, equality for all individuals in the society, fairness.
Actually, sir, I want to say something more. Actually, justice cannot be defined in a simple terms because different people has defined it differently. So just from the Aristotle up to the Amartya Sen, and now there are so many definition of the justice. But if we try to define it, then we will say that the justice is that thing which is according to the people's just need, desire, requirement, and just according to their just equitable behavior, which is not according to the law, but according to the natural justice and something more.
Yes. Okay. So I understand the difficulty of defining what is justice, right? But however, see, we are not looking at the definition given by somebody because we are looking at how we understood justice. I got very good responses: fairness, balance of persons' rights, timely delivery of judgments, fulfilling the rights, and as the speaker has already said, equitable behavior. A few, yeah, fine. So in a simple term, if I want to define, I would say that the process of a result of using laws to fairly judge cases, redress injuries, and punishments. This is what the dictionary is giving us. Okay, so what does it talk about? It says the process, or that means what procedure that we are using and what is the result of using law to fairly judge a case. That means whenever there comes a dispute, what process we are using and what is the result that is. And also in case of crimes, how do you punish this? Many of you spoke about fairness, the fairness in the way people who are dealt with. Then the other simple way of understanding that the system of law in a country that judges and punishes them. It's a kind of a very limited definition of justice, but the justice, as we all understand, will have much broader meaning. So therefore, if we are looking at justice in a simple terms as a legal professionals, that whenever a person has some problem, that that problem shall be dealt fairly and decided fairly. Now let us understand what does access to justice includes. Can I have a quick response? What does access to justice includes? Understand, we are talking about justice means in a settlement of disputes, etc. And what, how do we deal with them fairly? So what does it mean? Access. What does it mean? The first one I will give because right to litigate is one part. So therefore, access to court is, yes, yeah. Somebody said availability. I think my volume is fine. Okay. Somebody said approaching to the court. Okay. Uh, Problem is gaining access to legal system means what? Are you talking about only to the court or anything else? That's what I want. Availability of the advocates, fees.
Actually,
Yes.
sir, I want to say something. Actually, access to justice should be meant that the state should give the social security and the just all welfare state concept, just like that people who are not approachable to the amenities, convenience, or facilities that they should give in, or if any injustice has been occurred with anyone, that should be rectified through the correct legal process. I think it should be the meaning of the justice.
Okay, that's nice. Now I'm getting so many responses, and I'm really happy to see that it is not just restricted to what we generally look at is access to justice is access to uh, court. So it is much more than access to court. Because if you want to go to court, the first thing that you need to understand is that you have a legal issue and it could be redressed. So therefore, ability to recognize legal issue, that means I have a problem and this problem could be solved by somebody somewhere if I approach. So that ability that the citizenry should have. Then the third one I'm looking at is that ability to seek help, whether you are able to, please don't meddle with my presentation. The ability to recognize, ability to seek help is that whether you, once you recognize that there is a legal issue, you're able to seek help. And if you're able to seek help from whom? Like somebody has mentioned that the availability of the advocates. That's very important. Definitely it is. Then many people also have said that the affordability, that means the fees, the, the lawyer's fees, whether we will be able to reduce that, and affordability is other one. And the next one is uh, timely remedy. That means if I go to the court or if I go to some authority for my uh, resolution of dispute, whether I do within a time. That is another issue that we are also looking at. Then whether the system that where we are approaching is fair, whether we expect that we get an unbiased outcome is also part of access to justice. Uh, Please understand this is a very, very important aspect of access to justice. Means I can go to the court, courts are available. I have advocates, I can afford for an advocate. But whether the court is unbiased, whether it is going to adopt a fair process for me, and am I going to get an outcome that is fairly used by the court? So therefore, the integrity of the court, or what we call the neutrality of the judges, is also a very much big part of access to justice. And it is not only judges, anybody who is supposed to give you a remedy, that person must unbiasedly give you his decision. So therefore, the access to justice going to the court is only a very minute aspect. There are many places, or I would say at least 90% of our issues are dealt by the executive. We don't go to judiciary for everything. A simple example of when you apply for a license, when you are applying for a driving license, you ask for a passport, you ask for a, you want to register for an Aadhaar card, whatever simple things. Who does that? It's not the court. So therefore, there is a much larger picture of access to justice, particularly when the executive is involved in offering what we need. Because I remember somebody said, justice is giving what they need. So therefore, in that sense, we need that unbiased outcomes. And the another aspect of access to justice, I look at it is enforcement of rights. So we have a constitutional rights, we have fundamental rights, we have legal rights. How these legal rights are enforced, how are my fundamental rights are enforced. Now, there is a greater debate when it comes to a fundamental rights. Because as a constitutional law student and as a constitutional law teacher, when we are teaching part 3 of the Constitution, we always focus fundamental rights are more or less a negative rights against the state because it imposes an obligation on the state to not be violent. Of course, there are few fundamental rights which also imposes a positive obligation for the government. But is it sufficient that the government not violate my fundamental right, or is also the government should ensure my fundamental right is upheld? Let me give you a simple example. For example, if my freedom of speech and expression is restricted by the government, you have a remedy going to the court. What if my freedom of speech is restricted by a private entity, a private organization, a private political party, a private trade union? Is it the duty of the state to stand by me and protect my fundamental right? Is an issue. Now, a similar issue also will come under right to equality, because right to equality we claim against the state. What if that my right to equality is violated by my own father, my mother? Then no, there is no chance of going to the court for violation of it. I'll just give you an example. As a father, I give more pocket money to my son, but less pocket money to my daughter. Would there be an enforcement of any right? So therefore, access to justice in a formal way, we look at the court, we look at the executive, but there is also the the behavior of individuals like us. It a lot depends. As I told you, that executive is going to play a major role. So, do we have an accessibility to authorities? Uh, what I mean by accessibility is everything that you require, whether you need an electricity connection, you want a water connection, whether you need a license, whatever it is, how accessible the authorities are, how transparent they are, how quick they are, whether we would be able to seek the help from them. Understand they are called as a public servant. Remember Jawaharlal Nehru's statement. He once said, they all call me as a prime minister. Actually, they should have called me as a prime servant. So therefore, whether you are a minister, prime minister, chief minister, or any government officer, collector, whoever they are all public servants. So do we have an accessibility to those authorities, and how do we improve those accessibilities? This is a very important aspect. So now I am just moving into how the evolution of this concept of access to justice, moving from courts to the legal level. In a plain reading, if you look at access to courts, as we already discussed, whenever you have a litigation, go to the court, you will be able to file a case in the court, able to afford a lawyer. But access to justice has evolved from a pure formal dispute settlement from the courts to the legal. Now, let me ask this question. I'm going to ask a very fundamental question. What is the purpose of it? Is the purpose of the court to provide justice, or purpose of the court is to settle the dispute? You can type 1 if you feel that it is justice. You type 2, it is just to settle the dispute. So I'm just asking you the question. Okay. Which is already said 2. I don't. Okay. Ones are coming. Views are coming. Let us understand the setup. And let me give you a simple example. Suppose A was prosecuted for committing murder of B. Now the case goes to the sessions court. Finally, all the evidences were produced. Finally, the court says A is not guilty of killing B. Is justice done? Looks like. But somebody killed B. What happens to the case? Does the police investigate further and to find out who killed B? Or they stop the case? So, if there is no such extension of the case further, what did effectively the court do? The court did settle a dispute between the state and A whether A killed B. Now the court says A did not. Then who killed B? There is no further process. So similarly, if you go to a civil case, how does the court decide? The court decides based on the facts and evidences produced before the court. The court is not bothered about who is right and who is wrong. The court decides based on who has a better evidence. If I borrow money from you and I did not pay, and there is absolutely no evidence to show that I borrowed, ultimately, if you file a case against me, the court will give judgment in my favor, saying that there is no evidence to show that I am liable to pay for it. So therefore, the primary duty of the court is to settle the dispute, not to provide justice. Sometimes, while deciding the dispute, you may get justice. Of course, this is not to discourage the students who are attending this thing, but generally what happens in the classroom, we always as a teacher say that justice, go to court. Not necessary, because judges also have limitations. They only look at the facts available to them. There is a famous saying in the English court after listening to both the parties. The judge said, okay, am I supposed to know the truth? The lawyer said, no, you're supposed to know only the facts and the evidence produced by the lawyer. Yes, Balaji says justice based on evidence before it. Exactly. Now, if the evidence is not showing the truth, then what happened to justice? That's an issue. Therefore, now we need to move understanding access to justice from access to courts to legal empowerment. How do we empower the people legally to get what they want? As earlier, one of you has spoken about the role of welfare state. Now, what is the role of the welfare state? The role of the welfare state is that the state is supposed to take care of the people from cradle to graveyard. So therefore, in a welfare state, providing access to courts is not sufficient. There is also need for us to move towards legal empowerment. My third point is some of the social legal movements that have championed the access to justice. To name few, of course, there are many. A very prominent one is the public interest litigation, which was invented in the 80s. The public interest litigation has come up as a big way to provide instant justice for the thousands and sometimes lakhs of the people. Then came the movement of 1970s, of course, much more on legal aid, and local laws came much later. The legal aid movement, which emerged after an amendment of 39A, and then also establishing the National Legal Service Authority, State Legal Service Authority, district level, taluka level. Then a big wave of local adalats is another such a legal movement. RTI is am I audible now? Somebody
Yes, sir. Yes,
said
sir. Yes, sir. Yes, sir. The audible, sir.
okay. RTI is another way. The right to information after several years of fight, the RTI Act came, and it has provided a lot of access in a sense. Earlier, even though right to information being a fundamental right under 91A, but there is no proper setup to ask the information. Now, RTI has improved in leaps and bounds the access to justice where you could ask information from the people and they are bound to keep. Of course, it has its own pitfalls, but still, RTA has one of the uh, pioneer in improving access to justice in India. And again, as a constitutional law student, if you read 70s and 80s judgments in prison reforms, particularly championed by the Supreme Court, has improved a lot of access to justice to the particularly the under trial prisoners. Of course, LGBTQ plus is another important movement in legal empowerment and also access to justice. The anti-corruption crusade that we have seen early in late 2000. Uh, Again, these are all contributed. There are many other movements that came for the purpose of improving access to justice. Then you must be heard about 2016, the Sustainable Development Goals identified by the United Nations and adopted by all the uh, member states. Now, particularly, I want to draw your attention to Goal 16. Now, Goal 16 says promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all. Now, I'm focusing more on build effective, accountable, and inclusive institutions. That's the most important and fundamental for access to justice. Now, those institutions don't think the institutions are only executive or top levels. Right from your law school, whether your law school is accountable, whether it is inclusive, whether the leadership that has in the law schools, both the teachers, principals, whether they are accountable, they are allowing the students to be part of the decision making, right from there, right from there to the highest level. Then 16.C3 also talks about promote the rule of law at national and international levels and ensure equal access to justice for all. Now, this rule of law is another issue where we, we all say that everybody is under the constitution, nobody is above the constitution. So, whether you have a higher majority rule this country, you are still under the constitution. Because if you look at the constitution is a social contract between the citizens and the government. That's why we say we the people of India, right? We created the constitution and told the uh, representatives, elected representatives, look, we are electing you to rule us, but this is our agreement. Constitution is our agreement. Um, Similarly, you look at how it is focusing effective, accountable, transparent institutions and public access to information, protect fundamental freedoms. So that's very, very important. That means the role of the government is not just rule us, but also provide access to information, protect our freedoms. Now let us understand why it matters. Of course, access to justice matters in every country, whether you are a developed country, developing country, or underdeveloped country. It does. But because we are Indians, we need to understand why it matters. Now, I look at the fundamental principle, fundamental point in this is the diversity. India stands apart from the entire world when it comes to diversity. Now, look at the Indians, India as a country. In terms of its population, only China is close to us. But the China doesn't have diversity as much as we have. Probably you'll find out every religion in the world in India. We have regional diversities, language diversities, more than thousands of languages, cultural diversity, racial diversity. The amount of diversity that India has, the China has no, because it has almost 90 to 95% is homogeneous culture. Now, in terms of, and of course, and again, it is not a democratic country, therefore we cannot. In terms of democracy, the diversity that we have will be comparable only the America can has a diversity. But again, American diversity is mostly because of the migration. And America is as big country as India, but its population is nowhere matched to us. So therefore, the diversity, the amount of diversity, the amount of population, the country, the system that we follow, it requires access to justice to be very effective. The second issue is that I'm going to look at the social inequalities. The prevailing social inequalities, I don't think I need to explain to you. Once you are born in India, brought up in India, you understand how the caste system works, how regional systems work, how religious systems works. The poverty. The poverty is it's kind of it's a curse basically because it becomes a curse for people who are poor in terms of access to justice. Then delay and dependency before the courts. We know that at least another 50 years would take to clear all the cases that are pending now before the courts, if no other case comes within 50 years. The gaps between haves and have-nots, the one good thing that came with globalization is that the per capita income has jumped. But the fallout of that per capita income jump is that the gap between the poor and the rich has increased several folds. So, when there is a vast difference between haves and have-nots, that would really challenge our access to justice. Therefore, we need to understand that the vulnerable groups requires more protection. When I say vulnerable groups, it could be gender, gender-based, women, children, minorities, uh, language minority, then opinion minorities is a big minority. If I have an unpopular idea, I will not be able to fairly express. Okay. The transparency. The one of the biggest issue in India is the transparency. Now, I hope everybody has some idea about the Sanchar Sati app, uh, where the government asked all the mobile manufacturers to have pre-installed this app. Now, if you look at the government, what government is saying, why that Sanchar Sati app is important, it looks to be very uh, good app because it gives you protection. Uh, on paper, I'm saying. I'm not saying it is really good because I didn't check. But then why, what happened with that app? For example, when you buy mobile phones, most of the mobile phones are already pre-installed certain apps and come. Of course, those are all private apps. I understand the difference between governments. But what went wrong? What went wrong is the transparency. Why people were apprehensive about it. I'm not here to judge whether this app is good or bad. I'm just talking about the transparency. If the government is transparent to saying that why this app is important, what does it benefits, and give the opportunity for the people to download, allow them to delete, etc., then there wouldn't be this problem. So that's what we are talking about. See, whether you have a good intention, bad intention, I'm not judging that. What I'm judging is the transparency level when somebody takes a decision. Like as a teacher, if I take a decision telling my class students do this, now the students would always try to avoid it because I have not explained to them why I'm asking them to do, how important that is for them, what benefit they will get. So the transparency. So transparency improves your access to justice. Okay, so can you identify what are the barriers to the access to justice? Deepak, I'm not commenting on that, but when I'm just saying that when you are talking about a government app, generally there would be an apprehensions. Therefore, if the government has handled those apprehensions, maybe the attitude would have been different. Okay, barriers, ignorance is one barrier, lack of awareness is another barrier, yes. Poverty, anything else you think that what restrict you from accessing? Complex procedure, bureaucratic insensitivity, infrastructure, finance, delay, cost, judges, non-availability of the judges. I think you have identified much more than what I have identified. Lack of will or capabilities. Yes, that's correct practices. Yeah, the procedure, the cumbersome procedures in the court. Yes, I think you are all better than me. So that's the beauty. As a teacher, I always learn from my students. So broadly speaking, there are economic barriers that could be payment of fees to lawyers' fees, cost of litigation, etc. The systematic barriers are the procedural delays, the strict procedures, cumbersome procedures, technicality of the procedures, the cultural barriers, status, caste, religion, gender. There are many of these play a role when you are filing a case. Imagine a lower caste filing a case, or upper caste, uh, religious minorities filing against religious majorities, women against men, all those things. Geographical, yes, the distance is another issue. If you want to travel to the court too far, very difficult. Legal literacy is another one. The stereotyping is another issue. Stereotyping is that we always brand somebody, oh, they are like this. Um, Vulnerability. Now, can you understand that technology sometimes could be a barrier? Because we look at technology as a facilitator of access to justice. But sometimes technology itself is a problem to access. Yes, the digital divide, correct. Now, I'll just give you an example. See, for example, earlier, if I want to apply for, say, a driving license. Now, the form to fill the driving license is freely available. Government gives me free. But now it was made online, or they may ask you to print it. Now, I don't have a digital access. Then how am I going to do it? So now I have to go to a computer center. That fellow will charge me. Then I don't know how many of my age, when we appeared for 10th standard exam, our result used to come in a newspaper. Our numbers used to come in first class, second class, third class. We have to check numbers. So if one person has a newspaper, 10 of us, 20 of us can free this. Now, after the digital innovations in India, now the marks cards, results are all declared online. Now, I have seen in some of the towns, normal towns, small villages, where they have this digital divide, they are unable to access. First of all, they don't have digital literacy, so they're heavily depending upon these computer centers. They charge 50 rupees just to tell whether you passed or not. Look at that. So therefore, when we are talking access to justice, there is an access to justice. So that's the problem. Filling up the forms online, etc., is the area where when there is a digital divide, it will be difficult for them to. Now, let us look into our constitutional framework on particularly the access to justice. Now, the starting point is the preamble. If you look at the preamble, it says justice. Justice is used in three senses: socio-economic and political justice. That means the constitution is supposed to provide the socio-economic and political justice to it. The social front, economic front, and political front bring equality by eliminating all kinds of discriminations. So that is a direct reference to justice. Now, coming to the part three, of course, we all know that all the fundamental rights are supposed to provide you justice, and particularly Article 14, 15, 16, 17, 18, that is right to equality, then Article 21, then you could also see 20, 22, talks about the rights of the prisoners and accused and detainees. These are all showing how important that so access to justice. Now, Article 21 particularly talks about the procedure established. So therefore, every dispute that goes to the court must follow the procedure established by law. And thanks to the Supreme Court, that procedure established by law must be just, fair, and reasonable, which before Maneka Gandhi it is not. So that means even if the law prescribes a procedure, the procedure must be reasonable, fair, and just. Then we have the directive principles of state policy. There are many provisions which talks about importance of the access to justice. It talks about women, it talks about young age, protection to the children, workers, etc. And of course, 39A, which provides uh, legal aid as mandatory for all the disputes. And the judicial interpretations, if you are looking at, most of the time the courts are talking about access to justice. Now, if you look at the power of the Supreme Court, both under Article 32 as well as 142, in the interest of the justice, the Supreme Court can provide any remedy. So I ask all of you to look into Article 142. Article 142, the Supreme Court can provide any kind of remedy in the interest of justice. And there are several judgments where the sweeping changes were proposed by the Supreme Court using 142. Then, of course, the public interest litigation. Now, the public interest litigation, I look at three phases. A very, very important initiation started by the Supreme Court in improving the access to justice, where it relaxed the rules of locus standi. That means who can go to the court. General rule, we all know that whose right is violated can go to court. Can I go to court on behalf of somebody whose right is violated? The question would be, what is your interest? It's none of your business. However, that has changed by the Supreme Court. Now, improving access to justice, public interest litigation has played a very crucial role, and particularly if you see from 1970s to 80s, the focus of this public interest litigation is on social injustices. Injustices caused to the society at large, particularly the prison reforms, bonded laborers, women who are in distress, children who are working in factories under abnormal conditions, the rights of the workers. These are the areas where there is a lot of jurisprudence has developed by the Supreme Court. And the key focus is the epistolary jurisdiction. That is, court started accepting the letters, postcards as petitions. So you write to a judge, dear judge, this is what happened to me, and the court may accept that letter as a petition. Because under 32, once your fundamental right is violated, there is absolutely nothing will prevent the Supreme Court from taking, because it says appropriate to proceeding can approach to the Supreme Court. What is appropriate to proceeding, the Supreme Court decides. That's how even in letters, forget even letters, even a newspaper items was considered as a petition. And who are the actors using this? Mostly the lawyers, journalists, social activists, researchers who found how pathetic the prison conditions. Write in newspapers, somebody read on that, write a letter to the Supreme Court. Supreme Court accepted. So social activism at its peak in 1970s. However, when it comes to 90s, these rights have taken backstage. And the focus is more on environment. So green lawyers have come, we have green judges, we also have a green bench. So mostly the NGOs and specialized groups has taken over the public interest litigations, and the development has come from the court is for compliance of its rulings, continuously issuing continuous mandamus, that is forever. These kind of measures taken by the Supreme Court. Then the present situation, now the public interest litigation is also hijacked. What is started for the people who are vulnerable groups, downtrodden, poor, now it has gone to the people of haves and rich. Now, if you see the most of the public interest litigations, either they are having a tinge of political ambitions behind these religions. Of course, some of them are still on governance, they still do. But focus is on issues like accountability, good governance, coupled with many cases on whether it is a temple, mosque, religious issues, etc. Okay, so now you have seen those, even what generates more interest among the news items are not anymore on governments are downtrodden, but it is on politics and politically motivated religious groups petitions. So what started as a very important access to justice movement is hijacked now by the others. When it comes to institutional frameworks, I think all of you know these things are there. After the National Legal Service Authorities Act, you have up to taluka level, you have the legal aid programs sponsored by the government to provide access to justice. Then we have courts, we have forums like consumer forums and police complaint authorities are established in each state. There is complaints, ombudsman, CVC, state information commissioners, a number of tribunals that come up uh, in improving the access to justice. Then somebody asked about what is ADR. Now I'm bringing ADR here. The institutional framework we have already uh, brought an arbitration act. Both talks about arbitration and conciliation. It also promotes institutional arbitration. And now the mediation act has come. Lok adalats have started by the courts. Uh, Effort was there. I'm not saying that whether these all efforts have really fruitful and in improving access to justice. Of course not. They have their own efforts. Then comes the legal aid clinics where I'm bringing how the law schools, the law teachers, the law students can actively work in access to justice. Because see, one thing we should understand, if you look at National Legal Service Authorities Act, Section 12K, who is entitled for legal aid? I think probably 70% of Indian population is entitled for legal aid as per the definition. It says all women. So if you take women as at least 48% of the population is women, so everybody is entitled. Then the workers, people, SCs, STs, people who are affected by disasters, etc. So therefore, about 70% of Indian population technically entitled for free legal aid. Would the courts be in a position to do that? Would legal service authorities able to and also understand the legal service authorities provide legal aid in terms of litigation? What about the non-litigation services? For example, I am a I'm a simple employee. So one of my friend comes and asks me to stand as a surety that he's taking loan. I want to know what happens if I stand as a surety. So I want to advise. Would the legal service authorities provide advice? I want an affidavit to be prepared. I want to fill an application form. I want to file a complaint before the internal committee for sexual harassment. So these are the issues that I don't think the legal service authorities are. So that is where I firmly believe that the role of the law schools, what law schools, legal aid clinics are going to do. See, don't look at legal aid as a litigation service. That's only one aspect. There are 6 other aspects of legal. For example, legal advice, paralegal services, legal literacy, then law reform, ADR. Who is going to do that? I think law schools are in a better position because we have a reach, we have a manpower, of course, include women power, so, students, dedicated faculty. So therefore, how do we improve access to justice through legal aid clinics? One is that we need to improve the skills of the students. So handling the clients, able to give legal advices, their ability to prepare applications and other writing a complaint, etc. See, there are many initiations. For example, many colleges have started consumer clinic where they are actually defending the cases. And recently, last semester, we have started POSH Compliance Clinic, PCC. So this clinic is offering its consultation services for all educational institutions, for the members of the internal committee, and also the people who wanted to file, the women who wanted to file the sexual harassment cases. And we are not just helping them, we are also helping the institutions to comply with the POSH Act. That's very important. So therefore, each college, depending upon their expertise, could look into the legal compliance clinic. Somebody can start with RTI compliance clinic. So you go to institutions and tell what are the requirements under that. Somebody could go and look into what are the requirements under the PWD Act. How their institution should be barrier-free access to the differently able persons. Law reform is another area where the students and the law colleges should seriously focus on looking at laws and what reforms are required to improve access to justice. So therefore, I'm just giving you a small a food for thought. You all know what happened with the Indigo, right? Of course, I'm also one of the victims. Stayed almost 7 hours in the airport and came back home because finally they could not fly the flight. Now, what kind of access to justice issues comes in this phase? Can somebody think about it? Identify it. And remember, we are all not illiterates. Most of them who are traveling in air are not illiterate. There may be few. And it is not that they are not even, all of them are poor. Still, first of all, what are our remedies? Can we think of? Now, Indigo is saying we will refund. Is that sufficient? Can somebody identify what are the things that the Indigo is liable? Because I don't know. I'm just a traveler. Compensation for what are the things that you can claim compensation for? That's what See, when you go to the court, compensation, you have to ask how much for what. Of course, one is my ticket, mental level. Would loss of business be remote damage? Yes, prior intimation was not given. Discomfort. Correct. My travel to airport, right? That nobody pays. Loss of opportunity. Does the Indigo knows that you are having a job interview? Can some law school start their consumer clinic and advertise the people whoever could not get into? We will start helping them to identify where we could file cases and how do we file cases. And what about the punishment for Indigo? Knowingly looking and continuing. And what is the role of the government? Why did the government kept quiet till last month? So I'm just putting 5 questions. I know I'm almost running out of time because I had to give you some question and answer. Um, so I have put about 5 or 6 questions just to think based on this. It could be used on anything, right? I'm just taking this Indigo issue because everybody, it is fresh in our mind. Say, for example, We need to identify what barriers, legal procedures, financial or informational barriers prevent passengers from taking timely remedies. So, does the members know where to file a case, which uh, which forum to approach, whether they should go to consumer forum, whether they should go to say court. Now, what happened? I booked the ticket. Suppose I'm traveling from Goa to Delhi. I went from Delhi to coming back. I'm not able to. So therefore, the violation is in Delhi. Whether I could be able to file a consumer complaint in Goa. What are those barriers? Can somebody talk about a class action? Yes, somebody. I think somebody said that class action. And I think Deepak was saying uh, maybe a class action. Yes. Does the existing regulatory framework provide meaningful access to justice for stranded passengers? What regulatory framework has? So it is very clear that if you have more than 2 hours delay, that you are supposed to provide refreshments to. What did the airlines do is they don't even inform them. Only when you demand, they start giving some vouchers. And when you go to take that voucher, they give 600 rupees voucher. And in airport, nothing is less than 600. So would that be sufficient for people to stay long enough? So the another question I'm raising is, how does power imbalance between corporations and ordinary persons shapes the ability to claim compensation and accountability? Now, how come I'm such a small a passenger can file a multi-crore corporation like Indian? That imbalance of power. And another question we were raising is, should we understand this access to justice beyond individual complaints to include systemic accountability? It is not that you are accountable only for an individual, but there should be a system of accountability. So, how does this entire fiasco has limited our access to justice when the fundamental services are breakdown? Don't look at only Indigo as one. It could be more. We have COVID, we have demonetization, we have many other disasters where there is no accountability. 2 days back, there was a fire accident in Goa, 25 people died. There is no accountability. Does justice require only legal remedies or also administrative response and transparency? Sure. Should the government also interfere, come up with an openness about why it happened, what it happened? Tell the people whether the government is accountable to the passengers to about what actually happened. So, so these are some of the questions that comes to mind when it comes to access. Right now, this is only one instance. There are several instances. So therefore, the last question I'm asking you now: what are you going to do with this entire Indigo issue? Maybe your legal aid cells or consumer clinics should put up posters saying that anybody who has any problem with that, please come to us. We will consumer forum. We'll be able to do that. So with that, I'm just stopping here and giving you, if you have any questions. Yeah, that is one issue, Manisha, you are asking about victimless crime, like in case of drugs usage, etc. Um, please understand, courts are managed by the individuals. Unfortunately, in law college, we teach court as nothing. It is not. Therefore, there won't be any consistencies in judgments as long as people are managing as judges. So that's why there should be, for example, now look at the powers of the governors. Punjab versus Union of India, what the Supreme Court said, and Tamil Nadu versus State of versus Union of India, what the Supreme Court said is consistent. But when it comes to 143, it is exactly different. So therefore, the consistency is the biggest problem, particularly when you have different, what we call the benches. So there were 3 ideas. Of course, in America, the American Supreme Court sits for all judgments, so therefore there is a uniformity. But one of the recommendation is that the judges, the Supreme Court level and High Court level, the benches should be divided based on the topic or the subject, so that they would be uniform. That means all the reservation issues goes to some, green issues will go into one different bench, like that. That's one of the recommendation came, but I am not sure, because it is the Supreme Court Chief Justice is the master of the rooster, which gives too much what we call discretion. So they decide the benches. Now, let me see some of the chapters. Yeah, I agree. In case of indigo, maybe a class action should be one of the way. I agree. Transparency of identifying indigent persons or too technical, varying statewide, I see as a barrier to access to justice. Deepak, see, understand that nothing can be structured saying that you give some kind of a rubrics and say this fellow will be indigent. So it has to be a case-to-case basis. There is no other way that we could look at it. Does justice always means right thing to do? Yes, technically, yes. What does access to justice means in the specific legal system being examined? We will look into how it is so easy to resolve your disputes, how it is easy to claim your entitlements. That is what decides your access to justice. Yeah, justice delayed is justice denied, but justice hurried is justice buried also. Now, why does this so many cases pending before the court? There are systematic, I think Kalpesh has done a lot of work on how to manage the course system. There are so many systemic difficulties, lack of what we call trust in the ADR methods that we are following. There are many others, but then of course the number of judges, number of lawyers available, number of judges available in India is much less compared to many other countries.
Yes, sir. I think, sir, you must be knowing about the court managers. 13 Finance Commission, they allocated 300 crore rupees for court manager in 2010. There's in 15 years, they are struggling. There are 450 court managers are there. So I've been interacting like many as court managers. So judges are reluctant, because they are there to facilitate judges. But judges, they want to do everything. So that is also one of the reason. In budget committee, infrastructure committee, this committee, they're telling हमको दे दो, give it to us. We see legal aid also, other things also. But again,
see, that is one of my
exactly.
comment is also when I submitted that the report on law school based legal aid fees. We have clearly recommended that national legal service authorities should be removed from the judges. It's not that the judges are incapable, but the judges are overburdened. They are not supposed to. And also, there will be a conflict of interest. So it should be run as a separate institute. That would have been much more beneficial, because I have seen number of places the judges are very reluctant to spend the money because they are not very sure whether the money will be spent for right purpose or not, because that would affect their promotions and other things. It's again the chicken and egg issue. That's why it should not be annexed with them. Now, this is exactly what is going to happen with the mediation. If you quote annexed mediation, it is going to be non-starter disasters, because again you are going to bring into so many technicalities. The Arbitration Act affected the same thing, bring it to technicalities. So we need a separate set of lawyers, separate set of what we call dispute settlers, who has this ADR into their head based on interest-based settlement. So that's what.
Sure, definitely, sir. So we'll close. I think there will be so many questions will be there. You will at least set the stage for upcoming session. So what do you, Ganga?
Yes, sir. Thank you, sir. Thank you so much for your effective session on introduction to access to justice. Now I request Ms. Pratishtha Shetty for vote of thanks.
Good evening to all present over here. On behalf of my institution, it's my privilege to extend the vote of thanks to thank each and every person who has contributed for today's event and made it a grand success on introduction to access to justice. Indeed, it's my great privilege to thank our today's resource person, Dr. M.R.K. Prasad, the Professor of Law, V.M. Salvakar Law College. Thank you, sir, for a beautiful session. Thank you, sir. I extend my sincere thanks for Dr. Kalpesh Kumar Gupta, for founder of Pro Bono India. Thank you, sir, for your collaboration and your presence. Thank you, sir. I extend my special thanks for the team management of K.L.E. Society's Law College Chikkodi, our board principal, Dr. D.V. Solapure. Thank you, sir, for your support and constant guidelines and organizing this meaningful session. Thank you, sir. I thank all the faculties and coordinators and technical team members and even participants who are present over here for making this event a grand success. Once again, I thank everyone.
Okay.
Thank you, everyone.
Prasad sir, thank you very much.
Thank you. I'll take it. Thank you.
Yes, thanks.